Court will call CR 28-22-8596, matter of State v. Jessop. It's time set for motion to reconsider and motion to dismiss.
Thank you, Judge. I believe Mr. Simmons is requesting a...
Court will call CR 28-22-8596, matter of State v. Jessop. It's time set for motion to reconsider and motion to dismiss. Mr. Schwartz.
Thank you, Judge. I believe Mr. Simmons is requesting a continuance based upon the fact that Mr. Hunter's in trial. I understand Mr. Simmons' position, so I don't have an objection. Part of the agreement for me not to object is that the state would agree that this would not be attributed as a delay by Mr. Jessop. If the court's willing to grant it, there might be some other issues to discuss, so I couldn't always want to hear them now. But if the court is going to continue it, I'd like to continue the pretrial on Friday because it's going to be a useless hearing if we don't have any further clarification on this.
Mr. Simmons.
I completely agree. That's accurate. This is through no fault of Mr. Schwartz or his client. I am asking for this continuance due to the really singular nature of this hearing and the history of this case. It makes a great deal of sense for Mr. Hunter to cover this. And so Mr. Schwartz has graciously not objected to that, and I certainly appreciate that. I don't have an objection really inherently to having it heard on the 11th. I will see if Mr. Hunter is available, but it's hard to tell given the status of the trial that's currently going on.
Okay.
So if not, then a reset for early next week would also be fine. I know that Monday morning is free for him, so that should work if Your Honor's calendar works. And Mr. Schwartz, of course.
Well, this is kind of an interesting dynamic. And Mr. Simmons, I've been in your position more times than I care to remember, where I'm in court on a case that's not mine, in that I haven't been involved in, and sometimes out of desperation agreed to a continuance because you're unfamiliar with the facts of the case. So I certainly understand that, and I understand that Mr. Schwartz is not objecting. But from the court's perspective, we are here on a matter that initially the city of Coeur d'Alene didn't appear on at the original setting. We're here on a misdemeanor case that has been pending for 14 months now. So I'm going to deny the request to continue. The court has put what I would consider fairly significant work into preparing for this hearing today. And for those reasons, I'm going to go forward. The difficulty that puts you in, Mr. Simmons, is not lost on this court. In terms of the motion for reconsideration, Mr. Schwartz, it's the court's position that the city failed to appear at the prior motion. The court did review the filing by Mr. Hunter with the city attorney's office, but would note that as it relates to the motion to consider, there was no objection filed. There was no, the city did not appear at that hearing. So it's unlikely that even if the court were to continue this matter, that it would allow the city to argue as it relates to the motion to reconsider. I recognize that Mr. Simmons is at a bit of a disadvantage, and Mr. Simmons, I don't pretend to hold you accountable for another attorney. As I indicated before, I worked in an office with several attorneys, and again, I understand the difficulties in having to appear on a case that is not necessarily your own, but as a representative of the state, it becomes your case when you walk through the doors. And while that may not be the most pleasant thing for an attorney to hear from a judge when they're looking at a situation like this, from the court's perspective, pushing this matter out again is anathema to the court's notions of justice. So I'm going to deny the request to continue. I'm going to allow Mr. Schwartz to argue first your motion to reconsider, and then we'll take up the motion to dismiss. Mr. Schwartz.
Thank you, Judge. Your Honor, I know the court's reviewed this, so I'll keep my comments on the motion to reconsider somewhat brief. I think it's important to just note, Judge, this was a difficult situation because we did have a visiting judge, which, as we just discussed, when you have people covering it, becomes problematic. And my issues with the way that hearing went, Your Honor, was that it was very clear, as the court mentioned, there's a lot of paperwork, there's a lot of filings, there's a lot of history to this case. And it was very clear that Judge Payne was simply just not in a position to have reviewed that and was not prepared to actually address the merits of the constitutional arguments or any of the case law that had been cited. So that makes it very difficult to proceed with a hearing. And you can see the consequences of that when Judge Payne basically stopped considering the motion and started just giving suggestions about what he wanted to see happen in the case. And he said things like, quotes were, Mr. Schwartz, just don't review the information, which is very troubling for a defense attorney to be told by a court, just don't review the evidence, which is just simply not proper. In the end, Judge, Mr. Hunter indicated to Judge Payne that he had no intention of using anything on these hard drives. And so the only sanction that was imposed by Judge Payne was excluding the evidence that the state had already said they were not going to use. And Judge Payne went further to say that I could still open the door by having my client testify, and then the state would be allowed to use the evidence that the court had excluded. So in essence, there was no actual sanction for the willful failure to comply with the court's order. I think it's important to talk about in this case, Judge, that you granted the motion to compel. Mr. Hunter, by his own email, confessed to withholding the information that the court had required be turned over for over a month. The only reason that he turned it over at that point was because I, in an attempt to be collegial, sent him an email prior to filing a motion for sanctions asking if the information would be forthcoming. And Mr. Hunter responded that he had some of it, had directed his assistant to not turn over the information, therefore being in willful, blatant contempt of this court's order. I think it's an important analogy to consider that quite often in the city of Coeur d'Alene cases, we deal with people, defendants that are facing probation violations for not filing something on time. And they have various and sundry reasons why they didn't do that, and all of those fall on deaf ears. And it's very concerning to me that Mr. Hunter believes that somehow the rules should apply to individual citizens, but not apply to the prosecuting attorney's office. In the email, he very clearly says, I have the information, I know the court's order it compelled, and I chose simply to not give it. That's contempt of court, Judge, and it gets other people thrown in jail. But Mr. Hunter's response is that it should mean nothing. Further, then after the hearing on the 20th of June, Mr. Hunter files a supplemental response to discovery saying that he, in essence, doesn't care what the judge has ordered, what you have ordered compelled, that he's simply not going to comply with it in any fashion. And I just don't understand the hubris of saying such a thing. I can't imagine myself ever going into court and saying, Judge, you ordered me to do this, and I just choose not to. It's like that old story, Bartleby, I prefer not to. That's not how the court system works. And
Mr. Schwartz, I apologize for interrupting. Have you received everything pursuant to this court's order to compel?
no.
Okay.
And the 620 supplement is what they say they're not over. And yesterday, after speaking to Mr. Mahara, which I'll get to some of the specifics of that later, I noted that they're continuing to deny it, not just in my case, but in other cases subsequent to this, where they've been ordered to turn this exact same information over. Judge Cafferty, on the 20th of July, gave them 7 days to provide this information, and the state did the exact same thing, said we're simply not going to comply with the court's order. There has to be a consequence to this kind of behavior. To allow this to continue means that Mr. Hunter will be able to do this in every case.
What's the nature of this evidence?
All of the information on the terabytes, Judge, if I can show, I provided it at the hearing with Judge Payne. I'm sure Mr. Simmons hasn't seen it.
No.
That's just the cover page of each device from the Celebrite reports.
Okay.
And the issue is, Judge, what they haven't turned over that you ordered compelled was the correspondence between these 3 FBI people that were conducting it. And if I can approach and hand
You may.
I know the court's probably familiar with Celebrite reports. This is the cover sheet of just one of the devices that was provided in the case. What happened in this situation, Judge, is the FBI uses one computer program. The police in Idaho use a different computer program. Upon the FBI completing their review of the 3 terabytes of data, they just sent it as a large lump back to the Sheriff's Department, or Post Falls Police, wherever Detective Welch works for. And so if you look there, it says that that's prepared by Welch. So they all say that Welch is the one that did it, because he then used Celebrite to just make new reports off of what the FBI did. So there are 3 FBI people that conducted these individual evaluations. There is no way to determine which one of those FBI agents did each device. And that's why the correspondence is needed, so we can determine who to subpoena and talk to about each individual device. And Mr. Hunter says that that's somehow work product that he is unable to get.
Well, the court already issued its ruling on that regarding that it's not work product. It doesn't fit within the rules. My recollection is that Mr. Hunter had argued that the court should adopt the federal rule and disregard the state rule as it relates to discovery. So from the court's perspective, it was not work product and it was subject to disclosure. As a matter of fact, I believe the court in its order to compel ordered that it be disclosed.
Absolutely correct, Your Honor. And that's the problem that I face now, is that I can't subpoena the correct witnesses to get these devices entered into evidence because there's no way to determine who's the person that did it.
Is there anything else that you have not been provided?
Not that you've ordered compelled, Judge.
Anything else that you've requested that you have not been provided?
No, Your Honor. There is a little bit of a further complication. That's why I filed the motion for judicial notice. The transcript of the trial that was previously conducted has, as I'm reviewing, I just got it a day ago, so it's hard for me to be super precise yet. But in my review of it, there's lots of information relied upon by the police officers in that testimony. Things like, we reviewed this website to determine this. We reviewed this to establish our expert testimony. So I'm already preparing a new supplemental request to get the information that the state relied on in that trial. But that's certainly not something that's before the court now, but I can say that there's going to be more requests coming. And as the court, I think, just absolutely summed it up, I understand, I've calmed down a bit about this case after reading some of these pleadings. I can understand Mr. Hunter's frustration where the federal government interferes with his case. I mean, they came and took all the evidence and they won't let him have it back. But that's not Mr. Jessop's fault.
Hang on a second, because I think this is an important distinction here. And Mr. Simmons, I'm going to ask you, when these cell phones were turned over, was there a warrant?
I believe so. I also believe it was a sealed federal warrant.
Okay. Do you know that to be true? I'm not asking about the existence of a sealed federal warrant. I'm simply asking, when Detective Welch turned these phones over, had that warrant been issued?
I believe so, but I cannot represent that for certainty. Simply because Mr. Hunter and Mr. Somerton have taken almost exclusive control of these cases. So I understand, I step into the shoes of the attorneys when I hear the court.
Well,
but unfortunately I can't make that representation.
the court has reviewed the supplemental filings in this matter, the supplemental request for discovery, and in one of those, Detective Welch says that he turned these cell phones over because the FBI was in the process of drafting a warrant. And the process of drafting a warrant is something different than seizing evidence pursuant to a warrant. And Mr. Hunter's admonition to the court, when the court indicated that evidence in the possession of a law enforcement agency at the direction of a local agency is imputed to in the possession of the state. Mr. Hunter said, no, that's not accurate, and there was discussion regarding whether or not the FBI was conducting their own investigation or this was done at the behest of a local law enforcement agency pursuant to the state's case. And that distinction is exceedingly important, because if it's an FBI investigation, then Mr. Hunter is absolutely correct. The court has to engage in the TUI analysis, which he has articulated. However, if the FBI was not, if they were doing this at the behest of a state agency, that's a different animal. Then they're acting as an agent of the state. And the possession of those devices is imputed to the state. So this court has been informed, and this is not the first time this court has asked this question. Back on April 4th, the court asked during the hearing on the motion to compel, how did these devices come to be in the possession of the FBI? What the court was told was that the FBI was not directly involved in the initial investigation. They were interested in taking a look at these devices and got a warrant. The court asked again, how did they come in possession of the devices? The court was told they applied for a federal warrant and obtained them pursuant to that warrant. So there's a bit of a disconnect here, and the court is mindful that we are treading an awfully thin line in terms of semantics if the representation made to the court was that these devices were seized pursuant to a federal warrant versus these devices were turned over to the FBI for an extraction and investigation absent the warrant, whether they were going to get a warrant or not. That is something completely different. And the representation that was made to this court that they were seized pursuant to this warrant, the court has a little bit of a trouble with. But at any event, Mr. Simmons, I know that you were not involved in this case, so the court's comments are for the record. And Mr. Schwartz, I didn't mean to interrupt. If you have additional information, go right ahead.
Just to follow up on the court's questions, I've asked Mr. Hunter about this, and I've never been able to get any answers. And in the Exhibit A that I filed, he specifically says to Judge Cafferty in Mr. Mahara's case that no one's allowed to look at it. And he suggests to Judge Cafferty, you should review this information in camera and not even let the defendant know. I understand that's the way that some of these things work. My issue is that none of this was addressed by Judge Payne, so we're still talking about the motion to reconsider. The end result of that hearing was Judge Payne freely admitting, because it's clear, the state had not complied with the order to compel. They had willfully done so. And at the end result was not a single sanction imposed upon them. And that's troubling to me. And it's certainly not how a defendant who's one day late on their evaluation is treated when they file something. An OSC is filed against them. I think this find Mr. Hunter in contempt for these pleadings by saying he made an argument to the court ruled, and Mr. Hunter's position was, I don't care what the court ruled, I'm simply not going to do it. And that's just not the way this is supposed to work. Prosecutors are agents of justice, and when they willfully don't follow the rules and willfully don't follow court orders, the entire system breaks down. And that's what this case is an example of. There's a reason that Mr. Hunter and I are so mad at each other about this case. It's because there is no path forward when the court doesn't have the power to solve the dispute. Often we disagree with the state about what the legal position is or what the ruling is. But once the ruling is happening, the arguing is done. At the end of this case, no matter how it turns out, Mr. Hunter could appeal the court's ruling about that order to compel. What the prosecutor is not empowered to do is simply ignore court orders and face no consequences for them. And that's, in regards to the motion to reconsider, that's really my issue with what had occurred.
Okay. As to your motion to dismiss.
Thank you, Judge. Your Honor, Rule 48 is pretty broad, and it gives the court discretion to dismiss a case for a lot of reasons, including anything that the court feels is in the interest of justice. The first issue is the delay caused in this case. And Mr. Hunter disputes that some of these things are his fault, but all the way back at the beginning when motions to suppress are having to be continued because Mr. Hunter files his brief at the 11th hour, the way he responds to that allegation is he says, that's the defendant seeking a continuance. The court may recall at that hearing, I specifically said, Judge, this is impossible for me to go forward due to this late filing. And Mr. Hunter said, I'm ready to proceed. And the court ruled, I'm not going to place Mr. Jessop and Mr. Schwartz in a situation where they have to address something that they haven't had time to review. I'm going to continue this matter. But all of that delay is caused by Mr. Hunter. Then we have the 3 terabyte situation that the court's very familiar with. Like we just spoke about, the court grants a motion to compel. Mr. Hunter, in a complete act of obstinance, just says, I'm not going to follow through with it for various and sundry reasons. But none of those are Mr. Jessop's faults. I understand the state has difficulties sometimes, but the goal here is to do justice. And if the state's unable to comply with the law and the rules, the result is dismissal. It's not just to go forward. What Mr. Hunter's position is, we can't follow the rules, we can't ensure Mr. Jessop's constitutional rights, but that's not my specific fault as Mr. Hunter, so the case can just go forward and Mr. Jessop's rights have to be diminished. And that's just simply not how this process is supposed to work. Additionally, as I cited in the brief, Judge, one of the things you look at under Rule 48 is whether lesser sanctions have been able to alleviate the problem. So normally, you would grant a motion to compel, and that would fix the situation. But it hasn't here, because the city still refuses to comply with the court's order. We are now at a roadblock created by the state's own actions. And the only person that suffers from that is Mr. Jessop. And that's why Rule 48 exists, is to prevent him from being prosecuted in a situation where he cannot avail himself of the rights and obligations that are codified in statutes and codes. But the motion to compel that you granted, Judge, you signed that in April. Several months later, a different judge with the exact same situation orders the exact same thing, and the state still doesn't comply and still says they won't. We're talking about multiple months of delay by not complying with the court's orders. And the only person that suffers from that is Mr. Jessop. There is no just way for this to go forward without the state following court's orders. It's just impossible. I can't zealously and adequately represent Mr. Jessop when two hands are tied behind my back because the state refuses to comply with the court's order. Additionally, Judge, now that we've had this trial and this transcript, I can tell the court that there's going to be a multiple hour-long motion in limine practice that we're going to have to do regarding the way the city proceeded on this case that went to trial. That's going to mean we have to find time for that, and that's going to be very difficult, considering that we have a pretrial in 2 days. So then I'm left with the Faustian choice again of, do I seek a continuance of the trial in order to address the situation caused by the state being obstinate? And that's not a situation that Mr. Jessop is supposed to be in. The state is the government. They're required to follow the rules. And I just don't see how the court or the city can expect me and Mr. Jessop to adequately address this case when information's withheld, court orders are ignored, and there's just inevitable delays. At the hearing in front of Judge Payne, one of the suggestions that Mr. Hunter made that Judge Payne ordered me to comply with was Mr. Hunter said, Mr. Mahara's case, they've gotten funding for an expert. Mr. Schwartz should just work with that expert, and that could solve all of these problems. And Judge Payne told me to do that. So since that hearing, I've been in communication with Mr. Mahara, and that's why I filed these pleadings where even with his expert making demands of what he needs to do to conduct the evaluation, the city refuses to comply. So I did what Mr. Hunter wanted. I tried to use this expert to save time and fix the problem, but they are obstinate with that expert as well. I spoke to Mr. Mahara again. His expert cannot go forward without this information that the city refuses to comply with. There is no path forward when the city is a roadblock to justice. And I don't understand why the city thinks that it's appropriate to respond in this way. If I filed these kind of pleadings, I would get disbarred. And I just don't understand the temerity to file such a thing and expect there to be no consequence. We're talking about a misdemeanor case that's 1.5 years old, has 3 binders worth of discovery, something like 16 supplemental discovery responses and more coming. This case has ground to a halt and has no path forward. Mr. Jessop's rights are the only thing that matter at this point. I would urge the court to dismiss this case using your discretion under Rule 48 in recognition of the state's obstinance and the effect that it has had upon this case's progression.
Thank you. Mr. Simmons?
Thank you, Judge. I'm going to rely pretty exclusively on Mr. Hunter's response to defendant's third motion to dismiss. This case hasn't ground to a halt. We're trying these cases right now, and we tried them previously. And so the remedy is not a dismissal, but is to take this to trial with the sanctions that are appropriate under Judge Payne's orders. I think it's important, though, to correct the record on the court minutes. Judge Payne specifically said, I don't believe Mr. Hunter is purposely obstructing. He screwed up and he didn't get it to you. He then later said, don't assume bad faith on the others. I think that's important. Mr. Hunter filed that response, and he also filed it with a declaration under penalty of perjury. So that's pretty extensive. Again, he has the most familiarity with that case, so I'm going to rely on that.
Final word, Mr. Schwartz.
I just don't understand that position that this wasn't willful. Mr. Hunter's email specifically says, I drafted the response containing the information that was ordered compelled in early April, and it was supposed to be filed then. But I asked my assistant to hold off on filing while I waited to hear back from the FBI. Mr. Hunter had the information. He wanted more information. So rather than give me what the court had ordered, Mr. Hunter decided to give me nothing. And it wasn't for weeks when I had heard nothing, and I sent him a very polite email asking him, what's the status of this? And his response is, I chose not to give it to you. It's willful, Judge. Whether he meant it to be obstructionist or not, he chose not to comply with the court's order on purpose.
Thank you. Well, both of these issues, the motion to reconsider and the motion to dismiss under Rule 48, those are both discretionary calls with the court, and the court recognizes that discretion. This court's decision is couched within that discretion, and the court has deliberated over the various alternatives that are available to it. The court is going to announce its decision, and in that pronouncement is going to provide the reasons for the court's decision. But I think initially it's important for the court to kind of lay out a timeline here. On June 12th of 2022, a citation was filed charging the defendant, Mr. Jessop, with criminal conspiracy under Idaho Code 18-1701 and nothing else. The court's perspective, that citation was defective and failed to provide notice to the defendant of what crime he was alleged to have committed. Conspiracy can attach itself to almost any crime in Title 18, in some other crimes, Title 49, etc. There was nothing else annotated to that. It was simply conspiracy. Conspiracy is not a standalone offense. Notification of rights form were submitted by the defendant on July 12th. Defendant filed a motion to appear by Zoom on July 13th, and the state objected. On August 9th of 2022, a not guilty plea was entered, and notice of appearance was filed by Mr. Schwartz. At that time, Mr. Schwartz submitted a discovery request of all materials pursuant to Idaho Criminal Rule 16 sub B sub 1 through 8. On August 22nd, the state provided a response to a discovery 71 days after Mr. Jessop's arrest in this case. In that response to discovery, there were 75 named witnesses. There's a box on that form that indicates whether additional information is forthcoming or not. That box was not checked, indicating that there was no additional information forthcoming. There's also a box on there that the state has requested additional information. That box was not checked, indicating that there was no request for additional information. There was also a link on that form that was provided to defense counsel for the CVs of expert witnesses. That link was inactive. On September 1st of 2022, the state filed its first supplemental response to discovery. Included in that was the Coeur d'Alene Police Department's operation plan dated June 6th of 2022. On September 13th of 2022, the defendant filed his motion to suppress, a memorandum in support of that motion, and a motion to enlarge time. The filing deadline in that matter was September 6th of 2022, making the motion to suppress roughly a week late. The state objected to the untimely filing. The state indicated in its objection that the state has timely provided all discovery in the state's possession within 14 days of the request. The state filed a response to the motion to suppress and then moved to strike the response, and the response was stricken. On September 15th of 2022, the state filed its second supplemental response to discovery. That supplemental response indicated that it contained the redacted 911 audio, Sergeant Averett supplemental report, and an email response from members of the SWAT team. This was in spite of the fact that at the previous, back on 9/13, the state had indicated it had timely provided all discovery in the state's possession. On September 15th, notice of hearing for the motion to suppress was sent, indicating that the hearing would be held on September 30th. On September 16th of 2022, Mr. Schwartz filed a motion to dismiss and a memorandum in support. The court set that hearing for the same date as the motion to suppress on September 30th. On September 21st, the defendant filed a motion to excuse the defendant from appearing at those hearings, and the state objected. On September 22nd, the state filed a sworn complaint curing the defect in the citation. It's important from the court's perspective, this occurred 102 days after the citation was filed. On September 22nd, the state's third supplemental response to discovery went out, including Coeur d'Alene Police Department supplemental reports from officers Newbill, Weisenfluh, Schmitz, and Welch. It added another witness, Earl King. Also on September 22nd, the state filed a motion to continue the motion to suppress and jury trial, citing unavailability of a material witness. On September 26th, defense counsel stipulated that motion to continue, and Mr. Jessop waived his right to a speedy trial. Pursuant to that stipulation, the state withdrew its objection to the untimely filing of the motion to suppress. The motion to suppress and motion to dismiss were reset by the court to November 21st of 2022. On September 27th, the state's fourth supplemental response to discovery was submitted. That included Coeur d'Alene Police Department supplemental reports from officers Guthrie and Cantrell and supplemental videos from Officer Cantrell. On October 21st of 2022, the state's fifth supplemental response to discovery was filed. That included a supplemental report from Coeur d'Alene Police Coeur d'Alene Police Officer Walther, and listed Walther as a potential witness. On November 17th of 2022, at 4:49 p.m. on a Thursday, the state filed its response to the defendant's motion to suppress, which was set for that coming Monday at 9 a.m. The next day, on Friday at 4:47 p.m., the state filed a response to the defendant's motion to dismiss that was set for Monday at 9 a.m. On November 21st, 2022, the court determined that the late filing by the state of the response to the motion to dismiss and the motion to suppress required a continuance of both matters. There was significant discussion on the record regarding how the parties wanted to proceed. Mr. Hunter at that time indicated to the court, number one, that he didn't believe that there was a time limit for filing a motion to response. Number two, indicated that he was ready to go forward and felt that there didn't need to be any additional time for Mr. Schwartz to be able to review those filings and proceed. The court cautioned that the court had not even reviewed them and was unprepared to go forward based on the late filing. And pursuant to that, continued the matters to December 12th of 2022. On November 25th, Mr. Jessop filed his response to his reply to the state's response. On November 28th, the state filed a motion for Zoom participation at the motion to suppress for law enforcement. I believe that was Trooper Archer, who was in the service of the armed forces. Mr. Schwartz did not object, and the court granted that motion. On December 9th of 2022, the state filed a motion for Zoom participation for another witness at the motion to suppress and filed a motion to shorten time to allow the request to be heard. It was noticed up for December 12th of 2022. At that hearing, the court denied the motion. The court stated its reasons on the record, but in particular, the court indicated that the difficulties sometimes with technology, not being able to have the witness in court so that the court could make credibility determinations was a reason for denying that motion. Pursuant to that, the motion to suppress had to be continued again on the state's motion. On December 13th of 2022, the state filed its 6th supplemental response to discovery, which included a signed affidavit to search warrant, probable cause order, return of a search warrant, and an order preserving. On December 19th of 2022, there was a stipulated motion to continue trial. On December 21st of 2022, there was a motion to continuation of the motion to suppress. On 12/27 of 2022, the motion to suppress and motion to dismiss were completed and submitted to the court. And that continuation on 12/21 was pursuant to, I believe we had a witness who was unavailable. He had to come back. We had to come back to court because the state's witness was not available on the first day, so we had to set a second day for him to come back. On January 13th of 2023, the court issued a decision denying the motion to dismiss. On January 23rd of 2023, the state's 7th supplemental response to discovery was submitted, which included 3.5 terabytes of information from cell phones, cameras, and other recording devices. On January 26th of this year, the court issued its decision denying the motion to suppress. On February 2nd of 2023, the state submitted its 8th supplemental response to discovery, which included body cam footage from Coeur d'Alene Police Department officers Gilbert, Buell, and Newbill. Again, this is in spite of the fact that the state had indicated back in September of 2022 that it had timely filed or provided all discovery in the state's possession within 14 days of the request. And yet, in February, body cam footage from Coeur d'Alene Police Department officers was submitted in their 8th supplemental response. February 10th of 2023, the state filed its 9th supplemental response, which included notice of compliance with Idaho Criminal Rule 16b sub 9 capital A regarding unredacted digital media. February 16th, the state submitted its 10th supplemental response to discovery, a supplemental report from Officer Welch and Cellbright reports. On March 6th, Mr. Schwartz filed his motion to compel discovery and a motion to dismiss pursuant to alleged discovery violations of Idaho Criminal Rule 16. On March 7th, the notice of hearing for that motion to compel and motion to dismiss was set for April 4th at 1:30. On March 28th, the state filed its response to the motion to compel. On March 29th, the state filed its 11th supplemental response to discovery, which included supplemental reports from Officer Welch. Of interest to the court, that supplemental report was completed in January and was provided to defense counsel in March. On April 5th, the court denies the motion to dismiss and grants in part the motion to compel. On May 12th, the state submitted its 12th supplemental response to discovery, indicating compliance marginally with this court's order to compel as it related to certain aspects of that order. On May 12th, the defendant filed a motion for sanctions. On May 16th, the state submitted its 13th supplemental response to discovery, being the CVs that it had requested. On May 31st, there was a hearing on defendant's motions for sanctions. That motion was heard by Judge Payne. Mr. Hunter has said on at least 3 occasions to this court that they had no intent to use the information contained in the 3.5 terabytes that was recovered from the digital devices that were seized in this matter. The sanction that was imposed was that the state could not use the digital information that was seized in this investigation. It's not much of a sanction from this court's perspective. On May 31st, the state's 14th supplemental response to discovery, an additional curriculum vitae. On June 2nd, Mr. Schwartz filed a motion to reconsider the court's decision and a motion for sanctions. Notice of hearing went out. It was set for July 3rd of 2023. On June 20th of 2023, the state filed its 15th supplemental response to discovery, indicating there was no authority to provide for communications between persons doing extractions from cellular devices in spite of the court's order. On June 26th of 2023, the state filed a motion for Zoom hearing and continuance of the motion to reconsider. There was no stipulation. It was never noticed for hearing. On July 3rd, the state failed to appear at the motion to reconsider. The court had cleared its afternoon docket and had no other matters on that docket. The state never filed an objection to the defendant's motion to reconsider. The court reset the hearing for August 9th of 2023. The court would note that pursuant to Mr. Hunter's response to Mr. Schwartz's motion to dismiss, he indicated that the court simply ignored his motion. The court did not ignore his motion for continuance or Zoom appearance. However, the court is not going to unilaterally act on a motion that has not been noticed up for hearing. Mr. Hunter then argued that the court should have called the office. The court is not in the business of calling and looking for attorneys when they're supposed to be in the court. Mr. Hunter indicated that the court is typically lenient with defense counsel when they fail to appear. The court would note that in all instances in this court's memory, the court is advised by either the bailiffs or Madam Clerk that defense attorney is running late and will be here. The court had received nothing for the July 3rd hearing, had no communication with the office of the Coeur d'Alene prosecuting attorney, and had no knowledge whether or not anyone was going to show up. In any event, they failed to appear. I think the court can certainly find that failure to appear acts as a waiver of their right to object to Mr. Schwartz's request for relief in his motion to reconsider. On July 7th, Mr. Schwartz filed his motion to dismiss under Rule 48. On July 25th, the state files a response to the defendant's motion to dismiss. On July 31st, the state filed its 16th supplemental response to discovery, including a chain of custody and supplemental reports from Coeur d'Alene Police Department Officer Welch. And on August 1st, last week, the state filed its 17th supplemental response to discovery, certified copies of city park permits. Again, this is all in the face of Mr. Hunter's statements over and over again that he is prepared for trial, and going back to September 13th, that the state has timely provided all discovery in the state's possession within 14 days of the request. In Thum v. State, it's an Idaho case found at 165 Idaho 405. It's a 2019 Idaho Supreme Court case. The court said, "We acknowledge and agree that late disclosure of evidence by the state may, in some cases, amount to a Brady violation. As the court held in Ingraldi, that's U.S. v. Ingraldi, that is 793 F. 2nd at 408. It's a First Circuit case from 1986. When the Brady issue is one of delayed disclosure as opposed to non-disclosure, the test is whether defendant's counsel was prevented by the delay from using the disclosed material effectively in preparing and presenting the defendant's case. The 10th Circuit has recognized that it would eviscerate the purpose of the Brady rule and encourage gamesmanship were we to allow the government to postpone disclosures to the last minute during trial." That's citing United States v. Burke, 571 F. 3rd, 1048, 10th Circuit case from 2009. The belated disclosure of impeachment or exculpatory information favorable to the accused violates due process when an earlier disclosure would have created a reasonable doubt of guilt. The court held further, where the district court concludes that the government was dilatory in its compliance with Brady to the prejudice of the defendant, the district court has discretion to determine an appropriate remedy, whether it be exclusion of the witness, limitation on the scope of permitted testimony, other instructions to the jury, or even mistrial. The Idaho court commented that we agree with the rationale of these persuasive cases. Thus, when the state is dilatory in its compliance with Brady, the trial court is given discretion to determine the appropriate remedy to address the state's carelessness. With that said, not every delay in disclosure of Brady material is necessarily prejudicial to the defense. To justify imposition of a remedy, the defense must articulate to the district court the reasons why the delay should be regarded as materially prejudicial. Courts should, when assessing the materiality of such a late disclosure, consider the significance of the late disclosure in light of the entire record. When assessing the materiality, the question is whether favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the verdict. So as to the late disclosure, the remedy proposed by Judge Payne was to limit the state's ability to utilize the 3.5 terabytes of digital information that was gleaned from the cell phones. As I indicated, the state has repeatedly said that they had no intention of using that. So from this court's perspective, that is not an appropriate sanction. The court is also mindful that it has to evaluate the sanction in light of the least restrictive sanction. So regarding the late disclosure, I think it would be appropriate if the state was restricted to the use of that evidence that it indicated it had fully disclosed up until September 15th of 2022, when it indicated that it had provided everything. That's not the end of the analysis. The court is also mindful that we have gone through a motion to suppress that spanned the course of 3 days. I believe 3 motions to dismiss. And when the court is evaluating the sanctions, looking at the prejudice to the defendant, the court is cognizant that Mr. Jessop has waived his right to a speedy trial. But I want to caution the parties. That waiver of a right to a speedy trial does not exist in perpetuity. It does not go on forever, and it doesn't permit the state to drag this matter on. The delays that the court has articulated in the timeline, I would find that the majority of them lend themselves to the state's disclosure of evidence. The failure of the state to have witnesses present at the time set for the motion to suppress, the late disclosure of the 3.5 terabytes of information that forced defense counsel to request a motion to continue, and even up until last week, August 1st, additional items of discovery coming from the state. I don't know how Mr. Jessop could receive a fair trial when we are 14 months into this and there are additional supplemental discovery responses coming in weekly. That being said, I can't say that the late disclosure, in terms of what the court has already gone through, would result in a different verdict. We are pretrial. We are in a posture of, currently we have a pretrial conference, I believe, set for Friday. So from the late disclosure perspective, the court's sanction in this manner would be appropriate. But it is not the end of the analysis. This court is disturbed by the state's noncompliance with the court's order, particularly in a case where the state was consistently saying that they have complied and with discovery and were ready for trial. When it becomes apparent to a prosecutor that for any reason he or she cannot comply with the court-ordered deadline for production of evidence, the appropriate action is to notify the court, seek relief from the order, and, if necessary, request postponement of the trial. That coming from State v. Hawkins, 131 Idaho 396, 1998 Court of Appeals case. The circumstances here demonstrate the potential for prejudice, not realized prejudice. And there's a caveat in there. because this court, when it went through the motion to suppress and the evidence that was adduced at the motion to suppress, and I want to be very cautious here, because the basis for the motion to suppress was lack of reasonable suspicion for the initial stop. The court at I believe the second motion to dismiss indicated that had Mr. Schwartz had the advantage of having that information available to him at the motion to suppress, it would not have changed the court's position as it related to the purpose of the stop. That is not to say that had Mr. Schwartz had that information, that items seized after the stop or post-arrest would not have been subject to suppression. And in particular, the court relied specifically on testimony from law enforcement regarding the presence of shields and the nature of dress of the individuals who were in the back of the van. Mr. Schwartz in his motion had submitted evidence that he received from the 3.5 terabytes of information that was after the motion to suppress that at least marginally could be construed as exculpatory in the sense that it was photographs of people purported to be protesting peacefully. Had the motion to suppress addressed those items, it certainly may have changed the court's mind as it relates to anything seized after the individuals were arrested. But again, that's potential prejudice and it's not actual prejudice, because we could always go back and do another motion to suppress. When we're talking about evidence that has not been disclosed, and certainly Mr. Schwartz has indicated to this court that the state has failed to comply with this motion to compel. The court views this in the nature of lost evidence or evidence that the state has refused to disclose. In that instance, the court has to look at a different analysis, and the court views this as a lost evidence issue. The Due Process Clause of the 14th Amendment requires that criminal prosecutions comport with prevailing notions of fundamental fairness, which requires a meaningful opportunity to present a complete defense and constitutionally guaranteed access to evidence. Citing State v. Lewis 144, Idaho 66. The state has a constitutional duty to disclose all material exculpatory evidence known to the state or in its possession. As the United States Supreme Court held in Brady, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. Citing Brady 373 U.S. at 87. This is a crucial protection under the 14th Amendment because it helps ensure the fair administration of justice. In addition, a constitutional violation for failure to disclose material evidence requires a showing of a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Citing Stewart v. State 127 Idaho 806, a 1995 Idaho Supreme Court case. Arizona v. Youngblood, found at 488 U.S. 51, a 1988 United States Supreme Court case. In that case, the Supreme Court determined that if the content of the lost evidence is unknown and the item is therefore of only potentially exculpatory value, a due process violation will be established only if the defendant shows that the government acted in bad faith. The Idaho courts have adopted the Youngblood decision. In Stewart, the Idaho Supreme Court explained that for cases where the destroyed evidence is of unknown value, the Supreme Court's decision in Youngblood consolidates the three considerations which were enunciated in State v. Paradas through its reasoning that materiality and prejudice to the defense can be presumed where the government acts in bad faith. If the content of the lost evidence is unknown and the item is therefore of only potentially exculpatory value, a due process violation will be established only if the defendant shows that the government acted in bad faith. That's quoting directly from Arizona v. Youngblood. In conducting this analysis, the court engages in a case-by-case assessment of the fault of the government and the significance of the loss or destruction to the critical elements of the defendant's case, citing State v. Porter, 130 Idaho 772, and 1997 Idaho Supreme Court case. Bad faith is a high bar requiring more than mere negligence. Rather, bad faith refers to a calculated effort to circumvent the disclosure requirements established by Brady v. Maryland and its progeny. While a deviation from normal practice can indicate bad faith, the deviation must be accompanied by additional evidence of intent and calculated efforts. That's citing State v. Sarbacher, 168 Idaho 1, Idaho Supreme Court case from 2020. The Due Process Clause of the 14th Amendment guarantees that a state may not deprive any person of life, liberty, or property without due process of law. This clause has been interpreted to require states to ensure that criminal defendants' trials be fundamentally fair, citing Schwartzmiller v. Winters, 99 Idaho 18, 1978 Idaho Supreme Court case. To be regarded as fundamentally fair, a trial need not be error-free. As public officers, prosecutors have a duty to ensure that defendants receive fair trials, citing State v. Irwin, 9 Idaho 35, and 1903 Idaho Supreme Court case. So as it relates to the evidence that has not been provided, we can presume that it is exculpatory in nature. The question ultimately is whether the state has engaged in bad faith in failing to provide it. And of note to the court is the fact that Mr. Hunter did say he had that information. He told his assistant not to send it out. He was going to contact the FBI, but it fell off his radar. In any event, it wasn't provided to defense counsel. The court is somewhat conflicted on whether or not that rises to bad faith, particularly in light of the fact that I have no real knowledge of the manner in which these devices were turned over to the FBI. Mr. Hunter, I take him at his word. He said to the court when the court inquired that the FBI was not involved in the initial investigation. And yet these phones were turned over. The supplemental from Detective Welch indicates that he turned the phones over pursuant to the drafting of a search warrant. I don't know if that means that the warrant wasn't issued yet. I don't know if it means if it was issued. In any event, I have no knowledge of that. I've asked that question at least 3 times now. And semantics aside, I haven't gotten a straight answer. I believe Judge Cafferty in his decision that Mr. Schwartz asked the court to take judicial notice of. I will take judicial notice of that as it relates to the order of the court regarding the cell phones, that Judge Cafferty determined that the FBI was acting as an agent of the state, which I'm not going to draw a conclusion other than from his perspective and from mine. I would join in that decision based on the information before me. This court is not abdicating its discretion to Judge Cafferty, but I think it's informative, at least from a judicial notice standpoint. This court would reach the same conclusion, that the FBI, when it took these phones, was acting as an agent of the state. And the state has an obligation to turn over that evidence to defense counsel. When I look at the Rule 48 motion from Mr. Schwartz, I must first consider Idaho Criminal Rule 2A. That provides that these rules, the criminal rules, are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and elimination of unjustifiable expense and delay. Given the provisions in Idaho Criminal Rule 2, the factors that this court may consider in evaluating an Idaho Criminal Rule 48 motion include whether the interests of justice efficiency, and effective administration of the court's business will be served by dismissal of the criminal action and the effect the dismissal would have on the party's expense as well as the overall delay. And the court would say, see State v. Reynolds. Idaho Criminal Rule 48 provides dismissal on motion and notice. The court, on notice to all parties, may dismiss a criminal action on its own motion or on motion of any party on either of the following grounds. And Mr. Schwartz has indicated sub 2, for any other reason if the court concludes that dismissal will serve the ends of justice and the effective administration of the court's business. Again, referring to the objection submitted by the state on September 13th of 2022, the state fully complied with Rule 16 and timely provided defendant with all discovery in the state's possession within 14 days of defendant's request for it on August 9th. The court indicated in the timeline that it reviewed previously. On August 1st of 2023, the state filed its 17th supplemental response to discovery, certified copies of city park permits. On February 2nd of 2023, 8 months after the arrest in this case, the state submitted body cam footage from Coeur d'Alene Police Department officers, 3 officers. Body cam footage from 3 officers 8 months after the arrest in this case, in spite of the city telling the court that it had fully complied with all discoverable information in its possession. In spite of Mr. Hunter's admonition to the court that I could not, and the FBI having possession of the phones and the digital information could not be imputed to the city of Coeur d'Alene, this court frankly disagrees. I have seen no warrant. The indication preliminarily is that Detective Welch turned those phones over while the FBI was working on a warrant, but not presented with a warrant. That's information that I do not have before me, and certainly based on my review of everything I have before me indicates that they were turned over to the FBI. They were not seized by the FBI. Further, Mr. Hunter indicated that the FBI was not involved in the initial investigation. If they were not involved in the initial investigation, they are acting as agents of the state, and his refusal to comply with this court's order using the fact that this information, the information ordered to be produced, was in the possession of the FBI, and that this court's order had no bearing on them, is disingenuous. And the court finds that it's not sound legal reasoning. It was subject to disclosure. The court ordered it disclosed, and it simply has not been disclosed. On May 31st, at the motion for sanctions, Mr. Hunter told Judge Payne that he was ready for trial. There have been 4 supplemental responses to discovery since May 31st, when Mr. Hunter said he was ready for trial. At that point, Mr. Schwartz had still not received discovery that was ordered by the state. The disclosure of the supplemental report from Detective Welch that was provided at the end of March of 2023, that was submitted as Defendant's Exhibit A at the motion to compel on April 4th. Right at the top, Detective Welch shows that he completed this report on January 17th. Mr. Schwartz's original request for discovery filed on August 9th of 2022. Second page, number 4. Mr. Schwartz requests documents and tangible objects. Permit the defendant to inspect and copy all books, papers, documents, photographs, tangible objects, and copies and portions thereof, which are in the possession or control of the prosecuting attorney and which are material to the preparation of the defense. Mr. Schwartz did not receive compliance with that request. From this court's perspective, he still has not received compliance with that request. On March 28th of 2023, the state filed a response to the defendant's motion to compel, indicating that the state has timely disclosed all discoverable material in its possession as it had been received. 17 supplemental responses to discovery. The continued argument that discovery has been provided, and it hasn't been, not at any time has all of the discovery in the state's possession been disclosed to the defendant. I don't know how Mr. Schwartz can prepare for a trial when there has been this steady drip of discovery going on for 14 months, not to mention a dumping of 3.5 terabytes fully 7 months after the defendant was originally charged, not to mention that the defendant went 102 days not knowing what he was charged with. Citation was not cured for 102 days. I recognize that Mr. Jessop has waived his right to a speedy trial. As the court indicated, that does not go on in perpetuity. All of these delays are attributable to late and non-disclosure of evidence that has either specifically or in general terms been requested by Mr. Schwartz or Mr. Jessop through Mr. Schwartz. Mr. Schwartz has indicated that he has further learned of specific items that he is requesting in discovery and anticipates additional requests for those items. There was a request earlier today to continue this matter and vacate the pretrial conference that's currently set for this Friday, which would require the court to reset this trial and place it back on the court's calendar for an October setting, which would move it out another 2 months. We would be at that point 16 and a half months into a misdemeanor conspiracy case by the time we ever saw the inside of a trial or inside of a courtroom. I have never in my 10 years seen anything that even approaches this level of failure to properly disclose evidence. This to me smacks of gamesmanship, hiding behind the FBI when, from this court's perspective, the FBI was acting as an agent of the state. If the court were not to sanction this behavior, it would lead to the natural conclusion that the state could avoid disclosing evidence by partnering with the federal agency and playing a shell game with evidence. That I am not going to permit. I would find that the motion for Rule 48 is appropriate. I would grant the motion to dismiss, and I'm granting the motion to dismiss on a couple bases that are articulated in the rule. That first motion being it serves the ends of justice and effective administration of the court's business. There is no faith in the process when the prosecutor can play hide the ball with evidence. There is no faith in the process when there are not consequences of failing to comply with the court's order. The manner in which this case has proceeded is an affront to the notion of justice. Justice delayed is justice denied. We are now looking at potentially 16 and a half months until we get to trial on a misdemeanor. The court would further note that it has significantly affected the effective administration of the court's business. We had a 3-day motion to suppress. We've had 3, maybe even 4 motions to 3 motions to dismiss, now 4 if you count the Rule 48 motion. We've had a motion to compel. We have had a motion for sanctions. We have had a motion to reconsider, and there is no end in sight. And from the court's perspective, this is the only way that the court can find to instill some sense of justice back into this matter. And Mr. Schwartz, I would ask you to draft an order consistent with the requirements of Rule 48 and submit it to the court. You may have to get a transcript to properly do that. As I noted initially, the court reviewed this on 3 bases. the late disclosure. The court reviewed it on the lost evidence analysis pursuant to Arizona v. Youngblood. Again, the court indicated that if it was to provide a sanction under the late disclosure, it would cut discovery response back in September. But when the court went through the Youngblood analysis as to the information that was not provided to Mr. Schwartz pursuant to this court's order to compel, it determined that there is no way the court has any faith that Mr. Jessop would be able to get a fair trial based on this constant dribble of discovery that keeps coming in, again, over the course of the last 14 months, as well as the failure of the state to appear at the initial setting of the motion to reconsider, the state's failure to provide any indication to the court why it was not present, the state's blaming of the court for not simply acting on the motion, the state's failure to object to Mr. Schwartz's motion to reconsider at the outset, the fact that the state failed to amend the citation for over 3.5 months to actually provide notice to Mr. Jessop of what he was charged with. This is not justice. The court has no confidence that Mr. Jessop would be able to receive a fair trial in light of everything that the court has witnessed in this case. Anything further, Mr. Schwartz?
No, Your Honor.
Mr. Simmons?
No.
You have 42 days to appeal the court's decision. And if there's nothing further, the parties can be excused. Mr. Schwartz, it's probably going to take you some time to get me that order. Can you have it in by the end of next week?
Yes, Judge. If I need the transcript, it might be a little longer, but I think I could probably just get the audio.
You can get the audio
Yeah.
if that would be easier. I would just admonish you to make sure you look at Rule 40. I know you know the rule, but there are some very specific requirements as it relates to a dismissal pursuant to Rule 48.
Yes, Judge.
And Mr. Simmons, I apologize for keeping you here this long. I recognize that you were simply a member in that office, but the court felt it was important to make the record today.
Understood. I do have a very naive question, I suppose. Is that 42 days starting today or when the order is actually issued?
The oral pronouncement generally is the order of the court. So
Thank you, Judge.
I believe it's 42 days, isn't it?
I think so, Judge.
Yep.
Yeah.
Thank you, Judge.
Thank you.